A lot of developments today. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your #1 source for everything. It ends with us saga. First, to get fully caught up to speed, if you missed the video I posted just before this one, Team Baldoni has withdrawn their subpoena against Taylor Swift. Watch that video to find out why. This video is about some other legal moves from a few of the parties involved and one major mistake. Lying to the judge is not a good move, I think, especially when there have been documents submitted to the court that can easily discredit what you say. Team Baldoni filed a response to a motion to compel them to share information about the sexual harassment investigation. I told you about that in a video earlier this week. The accused racist and her team wanted Wayfarer to share with them their findings. This investigation about the alleged sexual harassment against Crying Ryan's wife by Baldoni is being led by an independent law firm, and the investigation began earlier this year in 2025. So, Team Pinocchio wants information. They now are fighting, pushing back against that. In a letter to the judge, Baldoni's lawyers say, quote, Lively first contends that the investigation is a disingenuous charade because the Wayfarer entities should have but failed to investigate Miss Lively's concerns when she first raised them in May 2023 distorts the record. Lively fails to note that her allegations were first disclosed on December 20th, 2024 in the complaint Lively filed with the California Civil Rights Department. You all know I want justice for Justin and I support him. But you also know I'm not team him or team her. I'm team the truth. We remember the 17 or 30 point list. I think there were actually 2 lists. Insafra Blake presented a long list of demands. Remember, this was during the strikes. Several of the professional guilds were on strike or close to striking, and there was a work stoppage. The shampoo company owner threatened not to return to work unless her list of demands were met. There was a meeting. They went over her list. This happened way before December of 2024. Wayfarer was aware of her grievances way before December of 2024, as they allege in this new letter to the judge. In fact, he even agreed to sign a side letter that specifically stated they would not retaliate against her for bringing up her sexual harassment claims. This new letter, seeking to deny their motion to compel the information, the Baldoni letter, mistake so far. Let's get to the rest of it. The current investigation was promptly initiated by Wayfarer in January 2025 when Wayfarer retained Rains, Feldman, and Luttrell, LLP, and Adam Investigations Counsel, collectively investigators, to conduct an independent investigation into Lively's newly surfaced claims. Newly surfaced claims? Second, as Lively is well aware, the investigation is ongoing. As I told you all, I hypothesized it probably had not finished. The investigation was not done, and they've just confirmed that. The Baldoni letter continues, accordingly, the investigators' findings, reports, witness statements, and related materials have not been disclosed to Wayfarer. So they don't even have it. No info from the investigations in their possession yet. Accordingly, the Wayfarer entities have no documents in their possessions, custody, or control that are responsive to Lively's request, and so informed Lively's counsel on May the 10th. As this court has previously held, a party cannot be compelled to produce materials it does not possess. The Wayfarer entities have made it clear and reaffirm here that if and when any responsive, non-privileged materials are received upon the conclusion of the investigation, they will be reviewed and produced in accordance with the Wayfarer entities' discovery obligations. Third, Lively's contention that the materials from the ongoing investigation fall outside the protections of the attorney-client privilege and work product doctrine is baseless and contrary to well-settled law. The investigation is being conducted by outside legal counsel retained to independently evaluate Lively's recent allegations through a confidential, privileged legal process. Additionally, Lively's demand that the Wayfarer entities identify all witnesses contacted and turn over notes, recordings, and communications relating to those interviews, even while the investigation is still underway, is not only invasive and unprecedented, it seeks to undermine the investigative process itself. Especially given the high-profile nature of this litigation, premature disclosure of the requested materials would risk chilling witness candor, distorting the fact-gathering process, and undermining the neutrality that is fundamental to a credible inquiry. Finally, the investigators to whom Lively issued a subpoena have properly objected to the subpoena on privilege and work product grounds. Meaning, it's out of our hands, we're not conducting this investigation. And the investigators have objected to the subpoena. This is good. I love when they throw in a little sass. Should Lively wish to contest any specific privilege claims or other objections, the appropriate route is to do so via the subpoena process, not by seeking to compel the Wayfarer entities to produce materials they have not received. For these reasons, the Wayfarer entities respectfully request that the court deny Lively's motion to compel. That seems very sensible to me, and if I were the judge, I would agree with them. Additionally, some other behind-the-scenes drama going on. The high school graduate's publicist is bickering with a reporter for the Daily Mail. A lawyer for Leslie Sloan has submitted a letter to the judge requesting journalist James Vitushka to share information with Team Sloan and the power couple. Sloan wants text messages and other communications shared between the Daily Mail reporter and some of the Wayfarer parties. She says this discovery is central to the case, reveals to the judge that her attorney and the reporter's attorney were not able to come to an agreement on the discovery and whether to share it or not. In their letter, they claim the reporter's privilege does not apply, the privilege was waived, the material sought is not news-gathering material covered by the privileged, blah, 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 blah. The lawyer for the Daily Mail reporter submitted a letter to the judge today asking for an extension in time to reply to the motion to compel. I know, legal jargon. Here's what I don't understand, though, and why I'm inclined to deny the Leslie Sloan motion. This reporter is not a party to the lawsuit. His publicist and crisis PR expert are parties to the lawsuit. Any communications they had with this journalist could be gotten through the subpoena process of them, the parties to this lawsuit. This Daily Mail reporter does not need to be subpoenaed or supply anything, I think. The extension has just been granted, by the way. Now, thoughts on everything, including his team bending the truth to the judge? Let's discuss in the comments.